Hello, my name is Bo Johnson. I am the author of The End of Justice. This book is an expose as to why and how America is the most incarcerated country in the world. We are, with 5% of the global population, a people that account for up to 25% of the global prison population. Not many people are aware of this fact. People believe that America is a free country. But those who are informed and understand otherwise realize that if we are an incarcerated people, we cannot be free. The question is, why and how does this happen? In my book, I explain a thesis that the ignorance, apathy, and fear of the American people gives rise to the arrogance of governing officials like prosecutors at the local, state, and federal level who pursue numbers of convictions for their own personal gain. There are many characters involved in a criminal case. There's the alleged perpetrator who commits the alleged crime. There's the victim. And then there's the prosecutor, the investigators, and the witnesses, the judge. And then there is the evidence that is brought into the trial. Any number of these, or even a solitary example, for example, the prosecutor or the investigators, may be complicit in ensuring that an innocent man or woman ends up in prison. I created this documentary in an effort to highlight a case that I've been working on for several years now. Orlando Carter is an innocent man who is serving his 10th year of a 15-year sentence in a federal prison. Orlando Carter is innocent of the crimes for which he was charged. We now have proof from the federal government itself that, in fact, the Department of Justice, along with the FBI, sent an innocent man to prison. The characters involved in this case are numerous. There is Orlando Carter himself, who is alleged to have committed the crime of bank fraud. There is Assistant United States Attorney Richard Chema, who is the prosecutor who tried Carter in a federal court to ensure his conviction. There's FBI agent Kevin Gormley, who supposedly investigated the crime and confirmed, in fact, that the crime was committed by Carter. There is Judge Sandra Beckwith, who allowed evidence and denied evidence from being entered into court in order to ensure a conviction. There are Carter's 3 defense attorneys, who will be discussed later in this documentary, who failed to actually confirm the evidence itself in order to disprove that he committed the crime. Of particular note, there is a central character to this tragedy by the name of James Smith. James Smith was an employee who actually worked for Orlando Carter at one point. Jim Smith, who is not a credible person, he lacks character. He actually testified in court that he lied so much that he lost track of his lies, was the person who orchestrated a scheme of which Orlando Carter knew nothing, and was able to convince not only a bank, but a county and county officials that a transaction needed to go through, in essence. So he was able to further a crime, and it's important to understand this because it's Jim Smith that was the key witness that was used by the FBI agent Kevin Gormley and Assistant United States Attorney Richard Chema in order to convince a jury that, in fact, Carter was complicit with the crime.
Given the central role that Jim Smith played working with Butler County and National City Bank, it would be reasonable to conclude that Carter may have been involved. But I would caution you to consider that Carter may have had poor judgment with respect to hiring and managing Jim Smith, but that in and of itself does not lead to the commission of a crime. In fact, I'd like to take a moment now and share an interview that I had with Orlando Carter just before the production of this documentary. Consider Orlando's explanation as to why he is in prison. Mr. Carter, I just have a simple question for you. Could you explain in your own words why you are in prison for 10 years with another 5 years to go?
Certainly I can. In 2005, the Department of Justice accepted false allegations that I had a $4 million loan guarantee with National City Bank, and that I failed to report this obligation, this alleged obligation, on various financial statements to other institutions. As a result, the Department of Justice prosecuted me for bank fraud. The Department of Justice never investigated the merits of the suspicious activity report submitted by National City Bank. Said the FBI and DOJ did not conduct a forensic financial audit to verify the existence of the alleged $4 million loan. I was the owner of CBST Acquisition, which is a Dynas Corporation subsidiary. CBST was a vendor to National City Bank. National City Bank purchased equipment for Butler County that CBST received and enhanced for a project. National City Bank intended to lease the equipment to Butler County. A purchase and lease is not a loan. This is critical to understand. The Department of Justice did not investigate National City Bank for banking violations with Butler County. Rather, the DOJ believed this bank's accusations and rejected my claim of innocence and pursued a flawed theory of prosecution rather than prove the crime of bank fraud could not have been committed. The government advanced that the crime occurred without substantiation. After I was convicted, Ted Johnson, a forensic financial auditor, determined that I did not have a $4 million obligation to National City Bank. In a separate investigation, the Department of the Treasury issued a finding in 2017 that CBST never had a $4 million loan with National City Bank. Yet, even with these irrefutable conclusions, the Department of Justice will not concede that the crime of bank fraud could not have been committed. United States Attorney Benjamin Glassman will not admit that his office has made a terrible mistake.
Dear Mr. Carter, the Office of the Comptroller of the Currency, OCC, is responding to your letter regarding the above-referenced financial institution. The OCC contacted the bank, which responded directly to you. In correspondence sent to this office, you requested the bank validate a $4 million debt with CBST Acquisition, LLC. The bank provided a copy of note signed by you on December 31st, 2003, in the amount of $250,000. The bank stated this is the only debt it has on file. The loan was a commercial loan, and the retention period for this type of loan is 10 years. The bank stated the loan was to have been paid on or before October 28, 2004. The bank further stated it has responded to James Johnson, your power of attorney on this account. Sincerely, Customer Assistance Group, the Office of the Comptroller of the Currency, January 30th, 2017.
There is a final character involved in this tragedy. Her name is Kay Rogers. Kay Rogers was the elected auditor for Butler County. She served in this position for some 12 years. The government tried Kay Rogers in a separate case. Kay Rogers, because she didn't have the money and she feared a long prison sentence, pled guilty to a crime she did not commit. This happens a lot in America. People fear the federal government. This lady, who was a public servant, decided that she was not willing to fight in order to prove her innocence. So she accepted a plea of guilt and 2 years in prison and is paying restitution of $4 million on the key element of the crime involved in her case and in Carter's case. It's significant to note that Kay Rogers did not testify at Carter's trial. Carter was not involved in Kay Rogers' trial. And both of them claim their innocence. With the evidence that we have from the federal government, we're able to prove the innocence of both Orlando Carter and Kay Rogers. I recently took a trip to Ohio to sit down with Carter's attorney, Dominic Mango. Mr. Mango knows Carter's case intimately. He understands the significance of not only the current evidence that exonerates Carter, he understands, in fact, that the Department of Justice and the FBI should have confirmed this evidence before they even decided to prosecute Carter. Given the technical language involved in what is a very complicated financial case, I'm going to interject comments as I speak with Nick Mango and explain certain elements as we move along in this documentary. I'm also going to use what I refer to as the four corners of justice diagram. The four corners of justice diagram is a schematic that allows someone like you and I, lay people, to look at the fundamentals or the simple elements of a case and understand what happened and then who was involved with whatever happened, so that you and I could understand, in fact, if an agent who was investigating did or did not do his job, if a judge ruled justly and correctly, if a United States attorney honestly and forthrightly gave the proper evidence and testimony from witnesses to a jury, and if, in fact, the witnesses testified truthfully. The point of this schematic is to allow us to score each element of a criminal trial. As we take a look at the four corners of justice diagram, we can see that the components are listed top to bottom on the left-hand side. We have a series of numbers that are found inside of a diamond, and through the heart or the center of the diamond is what I call the zero line. It is a list of zeros, so that if in fact every element that is involved in a criminal trial were to achieve a just conclusion without being favorable or disfavorable towards the alleged perpetrator, then we would presume, in fact, that the system did an adequate job and sought to achieve justice. If, in fact, a defense attorney or a judge or a United States attorney did something that was more lenient or favorable for the alleged perpetrator, then we would score a positive score to the right of the zero line. If, in fact, something happened that harmed the alleged perpetrator, then we would score it negatively. For example, let's say an FBI agent did not investigate the existence of a loan, as I allege in this case. Then I would be free to and be able to justify a negative score of, for example, -5 for the FBI agent. That would, in essence, prove, in fact, that Carter was not given a fair shake by the FBI to begin with. To keep this explanation simple, we can total the numbers on either the right or the left of the zero line and then reach a negative or positive score to prove, in fact, that justice was achieved. Ultimately, after reviewing the four corners of justice diagram, along with hearing Nick Mango's observations about government's conviction against Orlando Carter, you will be able to, at the end, make an assessment. You can make a determination and understand at that point, in fact, that America is an incarcerated country and perhaps maybe not a free country because of the system itself. There are two banks that are critical to this tragedy. One is National City Bank, and the other is Fifth Third Bank. Fifth Third Bank was Carter's personal bank. National City Bank, the bank that did business with one of Carter's companies. Carter owned two companies, Dynas Corporation and CBST Acquisitions, LLC. Jim Smith, his employee, the one who is not reputable in the least, was involved with CBST Acquisitions, LLC in working with a project that Butler County wanted to actually undertake, which was a wireless fiber optics ring. Jim Smith was the salesman. He worked with Butler County and National City Bank in order to move the project forward. National City Bank ran afoul with its banking regulations internally and with the federal government. And at a point certain in either 2007 or 2008, I'm not sure, the Office of the Comptroller of the Currency, the same agency that confirmed that Carter and his company did not have a loan with Citibank, it was the OCC that put National City Bank on probation. National City Bank, in a separate action, in fact, it was a suit by the DOJ against National City Bank, was found to have violated banking laws by charging minorities exorbitant fees in loan transactions in nearly 100,000 loans, of which 80,000 were loans for minorities. National City Bank was acquired by PNC Bank, and PNC Bank settled that suit to the tune of $13 million approximately to the United States federal government. National City Bank is a bank that had a culture of corruption, racial prejudice, and racial profiling. So it's not surprising that a component of National City Bank would do harm to Carter, as was done in his case. And it's a shame that whether it's Richard Schema or Benjamin Glassman, even today, never did hold National City accountable to the same culture in its violations with banking laws and against minorities as it did with Orlando Carter. National City Bank back in 2000, the early 2000s, let's say 2005, 6, 7, 8, had a culture that actually was indicative of what was done to you. And I'll give you an example. The same agency, the Office of the Comptroller of the Currency, that issued its finding that neither you nor your company had a $4 million obligation to National City Bank, issued a statement and placed National City Bank on probation for violating banking laws back in 2007, I believe. It was in a separate suit subsequent to that action that National City Bank was found to be guilty of charging minorities in over 80,000 loans as far as excessive fees. And PNC Bank, which acquired National City Bank, actually had to pay the fine. What are your closing comments on that?
Well, the prosecutors knew at the time they were prosecuting me that they were already engaged in wrongdoing. They chose to keep that information from the jury. In fact, they possessed an internal bank email that confirmed that they had already restructured transactions to elude improprieties. However, they chose not to let the jury know of this information.
Butler County has attempted to obtain information from National City Bank in Cincinnati. National City has not returned a single phone call. We have subsequently obtained and have in our possession documents of possible fraud in this transaction. Without contacting Butler County, it is our understanding the local bank of National City is reconstructing the transactions to elude any appearance of impropriety.
Kay Rogers was tried in a separate suit, and if I recall correctly, you were not a part of her legal proceeding against the government, and she was not a witness in your case. Is that correct?
That is correct.
And what is curious to me is that Kay Rogers has professed that she has lied to the court, and she lied to the court when she accepted the plea agreement because she accepted guilt for crimes she did not commit. Is that your understanding as well?
That is my understanding.
Okay.
And one thing I think to note there, I was not able to communicate or speak with Kay during the prosecution.
Right. That's exactly right. Now, going back to Kay Rogers, she accepted 2 years in prison because she didn't have the energy or the money to fight the federal government, and she feared getting up to 7 years in prison. And it's fairly common knowledge among people who find themselves in your position or Rogers' position that they accept plea agreements just to simply solve the problem. So I'm going to make an observation. I'm going to ask you for your comment. You are a black man, and we both know that your case involved racial animus. You are a minority. Kay Rogers was at the time and still is a single white woman. She is, in fact, a minority. It is noteworthy to me that she pled to something she did not do and therefore accepted a prison sentence and restitution for a loan that does not exist as a minority, while you, as a minority, as a black man, rejected a plea and no prison time because you knew that you did not commit the crime. You were tried and convicted, and instead of getting no prison time or probation, you were given 15 years in prison for somebody who has never committed an offense. I want to get your observations on that general tone.
Well, I think that observation is right on point. I knew all along that I never requested a loan, I never sought one, and certainly the bank never made me a $4 million loan. At the time the prosecutors came to me, I was adamant with that position, and even though they offered me a deal of probation, I knew I was innocent. And when you're right, you don't lay down. You have to fight. And the theory point of this is, even today when they know that a wrong has been done, they refuse to correct it. So unfortunately, Ms. Rogers went to prison over a loan that never existed simply because she was misled by the federal government, particularly the prosecutors in Cincinnati, Ohio.
Let's look and listen to the conversation with Dominic Mango.
And explain that Orlando Carter had a company called Dynas. He had a subsidiary that was CBST Acquisitions LLC. Correct. And Jim Smith was either the president or at one point the salesperson who was working on behalf of CBST Acquisitions LLC to facilitate the funding and the completion of a fiber optics ring for Butler County. Now, I just want to explain then that Carter and his company served as a vendor for Butler County and served as a vendor for National City Bank. And the loan, any loan, would have been, in essence, between National City Bank and Butler County, or it would have been a lease agreement, as I understand it.
Better way to put it. And again, that was something that, I had to go through the education of Theodore Johnson to understand that as simple as you can make it is the goods and services owned by Dynas CBST Acquisitions would be purchased by National City pursuant to a contract. There'd be payments made to buy the goods and services, and as that's done, then you have Butler County, who is then in agreement to lease those things that the bank purchased. So the bank is then leasing something to the county, and so the county would have lease payments as the equipment was going in. The vendor, then Dynas or CBST, would be servicing the county as part of this agreement between the three people.
Okay.
I use a car lease as an example. The bank or the financing company is going to buy the car from the dealer and then lease it to me. But when they buy the car from the dealer, they didn't loan the dealer money. They gave the dealer money. The dealer gave them goods or services to which they leased to me. That's where I think this confusion and misuse of terms is so important. And I've talked to my law clerk where, people tend to think of lawyers like, split hairs and make a big deal out of a word and it has an S or it doesn't. But in a case like this, if you don't have a forensic accounting expert, an auditor who can say what each term means and what its implications are, then misusing those can put dangerous because it can put it in this man in prison.
Right.
Because if you use the word loan and everybody accepts it, well, maybe he does have an obligation or a liability. I don't know. We have to go further. But if you understand that this was a payment that was made, and whether or not Jim Smith and or Kay Rogers procured that inappropriately, again, a different discussion because they're two different cases. There's no allegation by the government whatsoever up until very recently that Orlando conspired with either one of those two individuals. So that's why the use of the terms is so important.
Whereas, on or about August 31st, 2005, an invoice dated August 12, 2005, was presented to the K. Rogers, Auditor of Butler County, Ohio, by National City Commercial Capital Corporation, NCCC, seeking payment of lease payments allegedly due under a master lease agreement, dated September 14, 2004. The Board of County Commissioners of Butler County, Ohio, has refused to approve said invoice for payment and disputes that either the master lease or the lease amendment creates a legally enforceable obligation of Butler County, alleging that the master lease and the lease amendment were illegal, invalid, and unenforceable. Now, therefore, NCCC does hereby release and forever discharge Board, Auditor, and Butler County, together with any officer, agent, or employee of any of them, in both their official and individual capacity from any claim, including but not limited to damages, restitution, attorney fees, and litigation expenses. Demand or suit which arises from, is based upon, or is in any way derived from either the master lease or the lease amendment as referenced in this agreement. Signed, Vincent D. Rinaldi, Chief Executive Officer, May 26, 2006.
It is critical for us to understand that the very central theme for the government's case centers around the use of words. So Carter was either responsible for a loan or he was not. Or he was responsible for, in some way, a lease payment or he was not. But key to this is the fact that a lease payment or a purchase is not the same as a loan. Yet the government, throughout the trial, used the word loan, lease payment, advance, obligation. It never settled on a particular term. Take note of this as we move forward.
As a vendor, his company, as far as he was concerned, never had a loan and was never a guarantor of a $4 million loan. Without getting complicated, we do know that Jim Smith was not a reputable representative of Carter or his company, and he actually was playing National City and Butler County officials against each other and even against Orlando Carter, and a lot of people were in the dark about his scheming, what he was doing. And he actually signed something the size of a postcard that National City referred to as a guarantee. Explain that.
Well, my understanding is, and again, wasn't there, that I believe it was New Year's Eve, he was able to have a late night conversation with an executive of National City Bank and convince them that there were some questions about the deal that, again, the only contact person that they had was Jim Smith, that he would procure an opinion of counsel, a letter from the county prosecutor regarding the contract. And therefore, over the phone, they said, well, that's cool. We'll give you $4 million.
As you can see, Jim Smith was a schemer. He was central to this entire case. Carter was never alleged to have conspired with either Jim Smith or Kay Rogers. And the government never confirmed with any agency in the federal government, nor with National City Bank, as to the existence of an authentic $4 million loan. Meanwhile, Jim Smith had already signed documents on behalf of Butler County because he was given that authority, and he also signed documents on behalf of Carter and Carter's company, even though he did not have the authority. So Jim Smith, who had nefarious designs, was the central character that the government relied on in order to seek convictions from bigger fish.
He was accused of having a loan or loan proceeds or having a guarantee of a loan, and he did not give the money back upon demand. Is that a fair representation?
That's a fair representation of the government's theory.
The government's theory.
It's an inaccurate representation of what actually took place.
Okay. So is that the rub? Is that the crux of the matter then?
Yes.
Mr. Mango used the words government's theory. Did the government know that a crime was committed? Did the government substantiate with solid evidence that a crime was committed against a bank or the people at large? Or did the government use and misuse evidence in order to substantiate what was only a theory?
From my perspective, he was accused of having a loan with one bank, not reporting that loan on statements to his personal bank, and therefore charged with bank fraud. Is that in essence what happened?
Yes, and obtaining something that you otherwise wouldn't be entitled to.
All right.
Because the essence of fraud in a criminal court is not just that there's a misrepresentation. There's a material misrepresentation, and then a final element that you then receive some benefit that you're otherwise not entitled to.
So the line of credit he got with Fifth Third Bank, his personal bank, is something he would not have received otherwise.
That's the government's theory.
But Orlando Carter was offered a plea agreement, and the plea agreement amounted to, if you plead to your guilt of the charges, then you will in essence receive no prison time, receive probation, and you'll be a convicted felon. And then if that is a fair characterization of the offer, he turned it down and said, I'm innocent, I want my day in court.
If we contrast Carter's rejection of a plea agreement and no prison time with the furtherance of a government's theory that they need to prosecute in order for agents and prosecutors to seek personal gain, then we have a contrast of great significance. We have an innocent man fighting for his freedom, and we have government agents fighting for scores, fighting for convictions.
So Ted Johnson is a third-party independent expert who did the forensic audit, and he came to the conclusion that there was no loan. In fact, he came to the conclusion that if anything, what Carter had and what his company had was a contingent liability, which is
not the primary finding. It's almost a secondary finding where you would say, okay, for argument's sake, the government's theory is this, and for argument's sake, we believe these transactions and that theory, then at worst, there's a contingent liability. At worst. Which, the important thing that, from an accounting standpoint, and again, I wouldn't know this as a criminal defense attorney, that's why you have to have someone like him on board before you go to trial, while you're investigating the case. The biggest point of the contingent liability, according to the standards, accounting standards, is it doesn't create the liability for which they found Carter guilty. Because if it doesn't create that liability, then he going to Fifth Third with, I guess I would say the way it was booked was proper, and that was Mr. Johnson's findings.
okay.
And so far, he is the only expert from either side, in any point in the process, who's investigated the case and made a finding, and he put his name on it. It's an affidavit. He put attachments to make sure that it's supported by the evidence, and it's been filed with the court.
what does the FBI do to confirm the existence or the non-existence of that loan?
I can't and wouldn't want to speak for what the FBI does or should do, but I would say it's imperative that what should always be done would be a true forensic expert to do a proper forensic accounting and or audit. And I don't believe that was ever done in this case. That's I guess number one problem, and that's where again it begins with the investigation. If the investigation is done wrong, then everything that's built on that foundation is going to be the wrong theory as well. What they would do with that as part of their investigation, and how they investigate is a lot of times what we end up with where the problem starts.
Mm-hmm.
How, what, and who they investigate. Now, I wasn't there and I wasn't part of their investigation, but it would seem to me that they were given a theory initially, either by executives at National City, staff, or otherwise, and say, well, this is what we believe happened, and they would then run with that theory, and it would be my educated guess, because I'm sure this happened before, that then the investigation begins for the purposes of supporting a predetermined theory, as opposed to an investigation that is initiated or birthed for the purposes of finding the truth.
I think it does make sense. So you've got an FBI agent that receives an information, let's say, and at that point, given my somewhat limited understanding, I would wonder, does the agent have the training commensurate to make a determination on a forensic level, forensic financial level, in order to come to the conclusion that, yeah, a loan did or did not exist? It seems like a fair...
Well, that would be my first question in a case like this is, what is this particular agent, what's his background, what's his financial background, what's his accounting background? Well, I deal with a lot of very serious traffic offenses. There's traffic officers that do make stops and arrests that could tell you the traffic code inside and out. They would never be assigned as a detective in a murder case. They would not be qualified. I would assume, I think logic would dictate that you would have the same criteria on federal level, especially a complex banking case, especially a complex municipal lease agreement case that, it takes, accountants a long time to parse out what happened. That I think the biggest concern would be the training and background of the initial investigating officer. Because again, when you begin with an investigation, which in all cases do, if that's not done properly, then it's the foundation. Nothing on the foundation is going to be correct.
Ted Johnson was not a witness that testified on Carter's behalf during his trial. He did not have a forensic financial auditor who researched the case. Noteworthy, the government did not have a forensic financial auditor examine the documents either. But once Carter was convicted, he secured the assistance of Ted Johnson, who validated, in fact, that his company and he never had a financial liability to National City Bank. So Agent Gormley receives this SAR, this Suspicious Activity Report. I'm going to take this on a rabbit trail for a second. He could and probably should have hypothetically questioned the merits of the SAR to begin with. Why would a national bank, perhaps a multi-billion-dollar bank, make a representation that it's out $4 million? Maybe the SAR is suspect to begin with. One would expect an FBI agent to go that route initially. Maybe he did, maybe he didn't. But if the loan doesn't exist and he simply confirms the supposed merits of the SAR and advances that theory, he advances the theory to a United States Attorney's Office, who then may or may not confirm the veracity of those findings, and then it does what it does with the case in order to lead to an unjust conviction. Is that fair?
That's very fair.
You know, the thing that comes to mind as you make those closing comments is the fact that FBI agent Kevin Gormley was not qualified with the proper training to do a forensic examination of any kind. He doesn't have that training. And not only that, Assistant United States Attorney Richard Chema did not go to the Department of Treasury, and neither at the FBI or the DOJ went to National City Bank to hold them accountable to what probably was a prophylactic SAR, as your attorney states, a fake SAR, as I would state. So in essence, because of a schemer, Jim Smith, one of your employees who foisted this scheme on practically everybody, the FBI seized upon Jim Smith's scheme and went after bigger fish like you and Kay Rogers for their own glory. What are your comments?
Well, I think your statement there is very accurate. Again, had they chose to investigate and act dependently, they would have come to the same conclusion as the Office of the Comptroller. Instead, they chose to believe the word of bankers rather than go get certified bank documents from the record custodian at the bank. They never did that. Had they gone there, the record custodian would have told them, as it did on January 10th, that recently that the debt never existed. So the documents that they got from local bankers there in Cincinnati were fraudulent. They were fake. Today, neither the bank nor the Office of the Comptroller recognize these exhibits that they have used to incarcerate me for the last almost 10 years. It's really sad that these individuals refuse to do the right thing.
If he doesn't have the requisite training to handle a financial, perhaps forensic audit of a bank loan as to whether it does or does not exist, that anything that he sends forward as far as his findings to the United States Attorney might be suspect. And then the U.S. Attorney would then take that. Okay, go ahead.
It must be suspect, not might be.
Okay.
I mean, you can't.
All right.
It would have to be questioned, and it would have to be questioned by a financial expert.
Right.
I would expect that the federal government would want to do that. I don't know that they did in this case.
Okay.
My best guess would be not.
Referring back to the four corners of justice diagram, we can take a look at FBI agent Kevin Gormley's training and his decisions and actions. Clearly, he was not qualified to make a determination about a complex financial case, nor did he seek the experts that would help him and the FBI make the proper determinations to advance to the Department of Justice and the United States Attorney's Office.
And especially the United States Attorney should actually look at it independent of the FBI agent and his investigation and say, okay, we'll double check whether in fact there was a loan or not.
Exactly. That's exactly what's happening here. That's the problem that we see in this case, and unfortunately in many other cases where it begins with the theory that they believe, whether it's the initial federal agent or another investigating officer or some other law enforcement agency, and then everything else is gathered to support that, rather than finding evidence leading to the truth. And sometimes that could exonerate somebody. Maybe they find something exculpatory, whereas you were indicating maybe a crime never actually took place.
Right.
And that's not, I'm afraid, and I'm fearful of this case, this type of case, or other cases where I believe they go into it saying, that's not our job, is to find that a crime didn't happen. Our job is to find evidence to support the crime.
Right.
And that's where, that's this initial one.
FBI agent Gormley, if he had conducted something like what Mr. Johnson conducted to determine the existence or the non-existence of a loan, Gormley would have made a determination that no crime had been committed, and it would have been snuffed out right there.
I believe so, absolutely.
So
I find it interesting, not to get you off, though, that even when he got involved, and anyone who's interested, we provide a copy. He put together 2 affidavits in support.
This is Ted Johnson.
Ted Johnson with multiple attachments explaining 2 different theories of innocence, of complete innocence. And while the government responded and pounded on the table about, well, the jury found this, and never once, with all the federal government's vast resources, did they ever provide an accounting. They didn't have an expert of their own, which I will take a leap of faith and say they certainly have one working in one of those buildings somewhere.
Right.
And they never responded. They never responded because you cannot. When someone says this is the truth, well, you can argue other things, but if you go find someone else, I guarantee you, they find someone else with his exact qualifications, they're not going to like that person's answer. Mm-hmm. So they didn't get someone. I mean, why not? That's the biggest question. Carter is an innocent man convicted of something, and this is when I realized that I now correct people. Don't say that Orlando Carter, I don't say he's not guilty of the crime. I say the crime never took place. Mm. And Ted's the one that kind of explained that to me and made me see that.
As far as the U.S. Attorney's Office, the DOJ, the Department of Justice, how come you didn't have an internal expert actually do what Ted Johnson did? What's the motivation for not doing it? Is it just to get convictions? That might be an oversimplification.
Yeah, and I don't have an answer for you. That's what scares me the most when I see these situations. I say, is it, well, are they blinded and said, well, that's the crime that happened and we have to prove it? And maybe somebody says, yeah, I believe that crime happened, and I've got blinders on, I can't see anything else, I can't believe anything else. Does that happen? I don't know. Is it this race factor? I don't know. Do they believe their job is to get convictions? They can look at the, ABA model and say the American Bar Association, which says that the prosecutor's job is not to get convictions, is to seek the truth. And I think that that's problematic. Often would say, no, we're hired and we get a paycheck to get convictions. And that, I think, also use the same term, blinds people.
Right.
To this day, I can understand why the government would respond and say, here's our financial expert, here's the accounting, here's everything, and here's why it supports our theory and Orlando Carter's guilty. And we would be like, oh, you're right. But I think you're afraid of it if you won't do it.
Right.
Why should a private person, let alone somebody who's been incarcerated for nearly a decade, be hiring an expert?
Right.
They have to spend time, money, and resources when we're paying for these people to actually do this job.
You've got Orlando Carter, who believes vehemently in his own innocence, and as you said earlier in our conversation to start, he was willing to help and cooperate with the government in order for them to find the facts and the truth of the matter. And part of that would have been, hey, here are my corporate resolutions, here are CBST and Dynas records, and as you can see, there are no resolutions for us to bind the corporation to National City with either a loan or a guarantee of a loan. And so Gormley would have arrived at that conclusion by saying, you know what, there's no merit to the SAR, and he would have snuffed the investigation at that point. And
not necessarily.
Okay.
There could be merit to the investigation of Jim Smith's activities.
Okay.
Independent and perhaps even unknown to Orlando Carter. Under the master-servant laws and civil liability, maybe Orlando Carter could have some liability for what his employee does. Depends, those are different theories. There could still be merit to investigation of what Jim Smith was doing. He's admitted fraud. He told the government that in one drop, I've lied so many times I've lost track. So what could have been investigated there, but what's important to keep remembering, and it's disturbing how the government has been reckless in this regard in their court filings. Orlando Carter has never been accused of conspiring with Jim Smith or K. Rodgers in obtaining those signatures or that payment/advance on payment. So even if that was investigated properly, and accounting, there may be some merit to that investigation, but it would also result in realizing that Carter wasn't involved, which is what they determined. That's why there's two different theories and two different cases that aren't connected. They aren't co-defendants, they aren't co-conspirators. And just as importantly, that investigation, no matter how it came out for those individuals, would necessarily result in showing it didn't create a liability for Dynas, certainly not for Mr. Carter. So it's just as important that case, that investigation, which is different than the third, move forward and was done properly as well. Because while he was not a co-conspirator, that investigation would impact or affect this one.
Maybe Agent Gormley and maybe Assistant United States Attorney Richard Chema used the prestige of the United States government and the arrogance to advance a charge against Orlando Carter, who's pleading his innocence, in order to get Carter and maybe some other bigger fish.
Oh, absolutely. That's without question.
Without question. And so Jim Smith, who actually created the scheme and foisted upon all suspecting and unsuspecting parties, is in essence allowed to go scot-free, and while other people are paying the price for something he did.
Conversation with Orlando on the line, where it was communicated to him that they wanted bigger fish. There was definitely, I believe, from an investigator standpoint, an excitement about, there's going to be political big fish, there's going to be politicians involved, there's going to be splashy headlines. And I remember him telling me, yes, I was like, well, it's a good idea to help yourself out. And he said, I don't know anything. I don't know anything or anyone. Like
right.
The whole point of me trying to help them was to find out.
Right.
What you help me and I'll help them, and we'll find out who was involved in this, if anything.
Right.
If anything happened. He was shocked and surprised by it, but it was definitely communicated that that they wanted some bigger names, and he could help them. And, it wasn't that he refused. He was as open and honest as he could be, but I don't know.
The expression, the prestige of the federal government, is not uncommon. The federal government is feared by a lot of people, and rightly so. The government exerts its power, and its own prestige is enough to be able to abuse that authority and actually get people convicted or to plead to things they did not do. Referring to the four corners of justice diagram again, we should note that if Chema never secured authenticated records of any loan obligation between National City Bank, Carter, or his company, then his score should reflect this gross neglect. We have a sure understanding at this point, according to Mr. Mango, that FBI agent Kevin Gormley never challenged National City Bank their accusations that in fact a loan was owed by Carter or his company. It's also noteworthy to consider that Assistant United States Attorney Richard Chema apparently did not conduct his own independent investigation to ensure that the FBI did an adequate investigation in the first place. We can refer to the four corners of justice diagram at this point, get a sense as to whether the Department of Justice actually did its job in the first place as well.
Any judge that sees that paper napkin size postcard signature by Jim Smith for a guarantee, any judge would look at that and say, you know what, that's not a legitimate banking guarantee.
The judge has discretion to exclude evidence and something that they find inherently unreliable on its face.
Now, Mr. Mango was being quite politic with respect to noting that the judge can choose to exclude or not any given piece of evidence. But my summation of Judge Sandra Beckwith's actions or lack of actions with respect to the guarantee is noteworthy. Any judge that sits on a federal bench that looks at something the size of a postcard signed by a lowly salesman that works for a company as even remotely possibly a guarantee is quite suspicious. In my humble opinion, Judge Beckwith should have denied that quote-unquote guarantee as evidence. Carter's defense attorneys did not challenge it. What say you?
That's as simple as it gets.
That's as simple as it gets.
It's not challenged.
But Nick, the problem is that not only did they not object to the exhibits that really ensured Carter's conviction, they told Carter before trial, when Carter asked them, did you check on the existence of a $4 million loan / guarantee? And they told him yes.
They indicated, my understanding, again, this is communicating with Mr. Carter, was that they indicated that they had verified his existence.
His 3 defense attorneys admitted under oath during that hearing under the 2255 process that they, in fact, never verified the existence of the loan.
Correct. It came out then that they did consult with an accounting expert who's a fraction of the qualifications and credentials of Mr. Johnson, and did not actually attack the core issue, which would have been what the nature of the transaction was. What it should have been called, and the impact on the financials. Right. So actually missed the boat completely and wasted a lot of money. Could have done without that expert at all, and then never presented any of it.
Defense counsel is appropriately noted on the 4 corners of justice diagram. It's imperative to understand that Carter's 3 defense attorneys, private attorneys, not public defenders, these are attorneys he paid for, they never checked the existence of the $4 million loan. They never challenged the validity of the $4 million loan guarantee. Carter did not have a loan, and he did not have a guarantee. He was not a guarantor of a $4 million loan. The sad fact is that these attorneys told Carter before trial that they verified the existence of the loan and or guarantee. If they're using the witnesses in order to underscore that the loan exists or that the guarantee was credible, then people like, let's just say, for example, Anthony Schweier. He's the auditor from Clark Schaefer Hackett. Correct. And he is used as a witness, and he may not be as qualified as Ted Johnson, but he does what at trial? Witness for the government, by the way.
Not necessarily for me to say, but I think there could, someone could form the opinion that that may have been perjury on some levels.
As we get into the witnesses that testified at Carter's trial, we should refer to the 4 corners of justice diagram again. Anthony Schweier, who was an auditor that worked for Clark, Schaefer, and Hackett, as Nick Mango just mentioned, provided questionable testimony to court. It was Schweier who told the judge and the jury members, that in fact Carter had an obligation, that it should have been disclosed on Carter's personal and professional financial statements. Mr. Schweier, his testimony is contradicted by the forensic examination conducted by Ted Johnson. Ted Johnson was able to refute Schweier's testimony and provided affidavits under penalty of perjury testifying to the truth of the matter. Carter had no such obligation. Sean McAllister told the FBI that the guarantee was not adequate as a bank guarantee. Can you speak to that?
I can't in much detail, to be honest with you, because I don't want to speak of necessarily of facts that I don't know, but I agree that was what he stated to the FBI. So again, the red flag then should have almost caused a U-turn, as you said in the investigation. As opposed to, we're going after, well, let's go back. And a lot of U-turns should have been happening. But I think I keep going back to to Ted Johnson and those affidavits. I think that's your best explanation.
Right.
When you're saying, well, that was inadequate. Why? Well, this is someone that took, we're talking hundreds of hours, tons of resources, and laid it out in an affidavit with attachments of all the evidence and support that you need, including the reference gap, the accounting principles that says, well, this is how this works.
Mm-hmm.
So, and he even went into the things that you're talking about with McAllister to say what suffices in the banking industry, and as well as Ohio law to what you need for a corporate loan, and what is an LLC, and what type of company was this, and what was Jim Smith's authority. So it's laid out incredibly well in those documents.
When an FBI agent conducts its investigation, presuming that he's fully qualified to investigate the matter that he's investigating, he will go to somebody like McAllister, who would have been involved in the loan process, and if a witness at that time makes statements, the FBI agent will record those statements in what is called a 302, right? It's a 302 statement.
Correct.
And McAllister says a number of things, and one of them is it's inadequate as a banking guarantee. John McAllister is another witness that was interviewed by FBI agent Gormley. It was McAllister who was the underwriter involved with the transaction between National City Bank and Butler County. He was actually working for National City Bank. It was McAllister who actually told Gormley that the guarantee of the loan was inadequate as a banking guarantee. This is something that Judge Sandra Beckwith is presumed to have known to begin with. National City had problems with the quote-unquote loan to begin with. And we have in our possession an internal email, that Judge Beckwith denied to be presented to the jury, where National City Bank made direct reference to improprieties with the first loan.
Butler County has attempted to obtain information from National City Bank in Cincinnati. National City has not returned a single phone call. We have subsequently obtained and have in our possession documents of possible fraud in this transaction. Without contacting Butler County, it is our understanding the local bank of National City is reconstructing the transactions to elude any appearance of impropriety.
Right. Do you have any knowledge about that?
Just the extent of what you just said.
Right.
And obviously it was an internal email where they were concerned about basically their own practices, their own transaction. And I guess going back to the use of the word loan, getting off trend and not get off track, but think about this again. They're calling it a loan, but they want it back if something doesn't happen. But if that thing happens, we don't want our loan back. It's not a loan. It can't be a loan.
Right.
They're, by definition, the fact that they are now demanding it back because of something not happening, it can't be a loan.
Right.
I made a payment to someone, and whether or not we want to argue about this handwritten guarantee by someone with no authority to pay it back, based on a contingency. If that contingency happens, we're like, no, keep spending the money and buying the stuff and putting it in the ground. Well, a loan would have had repayment terms, things of that nature, like everyone, like a layperson can understand this.
Right.
And if there's not a loan, there's not something to be paid back. Ted Johnson's affidavits, he's like, well, what happens after a demand letter is done? He says, demand letter creates no liability whatsoever.
Mm-hmm. It's just a demand.
It creates an issue.
Yeah, sure.
And it could create a problem.
So we have to question what National City is doing. And if National City, in turn, has an internal email sent by their general counsel, Tom Barnhart, that basically says, hey, we've got improprieties with the first loan, i.e. we're making mistakes. So when we do the second loan, we need to somehow use a Band-Aid and connect the two together and make the issues go away. That's my analogy, okay? So they know there's something wrong. Now, if FBI agent Gormley had done a proper investigation, he could have connected not only the fact that McAllister said that the bank guarantee was not adequate, and looked at the internal email that said we have improprieties with our own loan documents. He could have then gone back to the suspicious activity report and said, something's rotten in Denmark. This really stinks. They're covering their hindquarters in order to in order to not only get their money back.
The one pervasive theme issue throughout the case is there's a whole lot of CYA going on.
Yeah.
You know, it starts in National City, but it goes right on through, I think, the investigation and the prosecution.
Yeah.
That's my, humble opinion.
Had FBI agent Gormley or a Assistant United States Attorney Richard Chema actually weighed into the PNC email from General Counsel to National City Bank executives and considered, in fact, that National City made mistakes internally with its transactions with Butler County, then the FBI and the DOJ would have known in advance that something quite suspicious was happening internally at the bank, and that itself would have relieved Carter of any wrongdoing. Had the jury been able to view that email, had the judge allowed it, the jury would have realized there were problems with the first loan. They handled the first loan not as a municipal loan. They handled it as a typical corporate loan, did they not?
It appeared that way, which again goes back to why none of this makes any sense. Is they've structured something as a loan, which then throws in the question: did anybody understand the transaction itself? Because again, without question, if you can look at K. Rogers' PSI, at least the beginning, till it contradicts itself, it states that the transaction was purchase, which means you pay for something, you purchase something, and then leasing it to a third party, i.e. Butler County. Right. So, what the first payment transaction was, I'm not 100% sure. It was not the subject of any criminal case or any liability whatsoever for criminal liability, civil, or creation of a debt.
Had they treated the first loan, if it was a loan, as a municipal loan, it was then that they would have sought the opinion of counsel letter.
Correct.
A municipal loan requires an opinion of counsel letter.
And I think that's where they were tripping over themselves, realizing, well, it's now time to release the $4 million payment, advance, funding, whatever you want to call it. And we're now in the throes of a municipal contract, which then requires the letter. So
Jim Smith, the person that's orchestrating the scheme here, is signing a guarantee that doesn't bind Carter or Carter's company, and National City wires the funds. So Carter and his company do the only thing that they should do. They make the purchase of substantial pallets of telecom equipment, and they start going to work, which is what the bank would expect them to do. Right? So they start going to work on the fiber optics ring for Butler County because Carter and his company is the vendor. And then all of a sudden, after a protracted period of time, let's say 6 months, just using round numbers, they still had yet to get the opinion of letter counsel from Butler County. So National City sends the demand letter, I think in February, and says, we want the money back. Is that the flow of events?
That's the flow of events. What would happen if they would have got the opinion of counsel? And the government's theory is this money was just completely embezzled and stolen and used for other things. And it's like, well, then I think the government's theory, if it would have been properly analyzed and dissected, collapsed, would say, well, you're saying that Dynamist should have sat around and done this
for 30 days.
For at least 30, maybe 6.
Maybe
how long?
Maybe 6 months.
County prosecutors don't move always that quick because we're not. So, and do nothing.
Right.
And then they get opinion count, and then the banks be like, what the F have you been doing this whole time?
Right.
Well, it wasn't our money. We might have had to give it back. So we couldn't spend it. No, we got it and started to use it. Again, and I understand, or you're going to say that the theory is, well, and Julie Lights and other people that testified said, well, yeah, it was booked as revenue, and then other debts were paid off. I would argue, and I think you might want to bring in another expert and say, that's a normal way to run a business. The evidence supports that there was not a loan, that there was not a debt, and there is just not simply a lack of evidence to the contrary. the government goes out of their way to take us down other roads.
Mm-hmm.
And talk about, well, co-conspirator, well, it said this and that. And they, in every pleading, pull everyone, anyway, want to look this, every single pleading interchangeably use loan, payment, advance, guarantee, promise,
Obligation.
Yeah.
Mm-hmm.
And again, if you're having a conversation by text with your friend, maybe it doesn't matter. But when one definition results in prison sentence and another definition by accounting terms doesn't, so that's kind of important.
The Fifth Third Bank saw the allegations. They said, oh, we got a disaster in the making. They shut his company down. They locked the doors. In the meantime,
Ensured a disaster.
Yeah, which ensured the disaster. That's a great point. Fifth Third Bank locked the doors. In the meantime, the 32 pallets or so of telecom equipment that was now enhanced goes back to National City. So they, in essence, get their $4 million back, do they not?
Well, they got value in goods and services, other than saying there's labor and collateral expenses to putting that together, shipping it, and procuring it. And they're demanding their $4 million.
We shouldn't be surprised that National City might actually submit a fake SARS to the federal government to get away from their own complicity, their own problems.
Yeah. And one might not say fake, but one might say a prophylactic SAR, where it's a compulsive knee-jerk reaction as this is our protection.
Right.
Like, hey, if I assault you, I call the police because I've got to be the first one to feed and drop. I've got to get my narrative out before you get yours out.
Right.
If there's one to get out.
Right.
So, I think of it in that regard. I hate to use the term fake or accuse people of pretty serious crimes. But I do think of it in almost a prophylactic sense of like, well, we're misusing this.
After working approximately 3 years on behalf of Orlando Carter and his case, and working with Nick Mango for the majority of that time, I met a pastor by the name of James Chisley in Cincinnati, Ohio. It was with him and the Baptist Ministers Conference in Cincinnati, Ohio, and we joined forces together and sent a letter to United States Attorney Benjamin Glassman, the current United States Attorney. And we presented Mr. Glassman with what we believed was credible evidence that, in fact, Carter was innocent of the crime. To his credit, Benjamin Glassman agreed to meet us, traveled to downtown Cincinnati, and met with him and Mr. Parker, his assistant. It was then, at the beginning of the meeting, before anything was spoken, that Mr. Glassman disclosed to us that they had shredded most of the documents involved in Carter's case, which would have included any authenticated and certified records that would have attested to the veracity and the existence of a $4 million loan or a loan guarantee. I looked at Mr. Glassman and I said, Mr. Glassman, you never had documents read in the first place. The FBI, the DOJ, never confirmed the existence of a $4 million loan or guarantee with either National City Bank or with the Department of Treasury.
First off, I wasn't there, but that statement was relayed to me by yourself and others in attendance. And as I stated, I find that troubling at best because I don't know that there was much time at all, any space in between where you'd say, well, this is a good time to start throwing things away. This case has been litigated, and the issue of the litigation, what's been challenged is the existence, and more importantly, the verification or lack thereof of any loan or actual obligation on the part of Dynas, Mr. Carter. Why that specifically would be the thing that was shredded. This again, puzzling at best to use stronger terms. My analogy is that, if you have a rape or a murder case and you save all the evidence except for the DNA, that DNA perhaps belongs to a different person, it would be exculpatory. we say, well, we saved all these things, we've got all this evidence, we can cite the transcript, but we didn't hang on to that DNA sample.
Right.
That would be extremely troubling to me, especially in any case if it was stagnant and nothing had been happening. Even more so in a case where litigation has been ongoing, challenges have been ongoing, letters and questions and concerns have never stopped. And the one thing you got rid of was the thing that either verified or not the existence of the only thing that would make that person guilty, the DNA. The only thing that could make him guilty, the only thing that could make him innocent is the one thing that you didn't keep.
Supposedly shredded, got rid of.
If you had it.
If agencies like the FBI or the DOJ, the United States Attorney's Office, is to keep records for up to 10 years, Carter's been in prison for 10 years and he's been litigating in a post-conviction status for 5 or 6 years. So in essence, it's well under the 10 years to keep records, because anybody who's acting as U.S. attorney who realizes a prisoner is litigating in order to be exonerated, the U.S. attorney would keep the records, would he not? I mean, this just stands to reason.
Yeah, common sense.
Common sense.
Yeah.
There would be no reason to shred the documents, is my point, right?
I would hope to God there would not be a reason in anybody's mind to shred the document.
Okay,
That's
so
not just relevant to someone's guilt or innocence, but proves or disproves it.
the Office of the Comptroller of the Currency is an agency of the Department of Treasury. And one of the functions of the OCC for the Department of Treasury is to regulate national banks. Orlando Carter sent a request to the Office of the Comptroller of the Currency in 2016, which is still under the 10 years with respect to his prosecution. And PNC Bank wrote to the OCC and said, there is no $4 million loan. We only have the existence of a $250,000 loan, which is dated 2 years prior to any supposed $4 million loan, which would be beyond the 10 years.
Dear V. Beck, from the Office of the Comptroller of the Currency, please allow me to respond to your request for additional information to PNC Bank. National Associations, PNC, original response dated November 2nd, 2016, regarding the above-referenced complaint. The bank must provide a response to the OCC Customer Assistance Group regarding the validity of the business debt. Response: there is a note signed by the customer on December 31st, 2003, in the amount of $250,000. This is the only debt that we have on file. It was to have been paid on or before October 28th, 2004. Sincerely, Aaron Bailey, PNC Bank Officer, Executive Client Relations, November 14th, 2016.
So PNC Bank proves the existence of a loan that's beyond 10 years, but the U.S. Attorney has no records for a loan that's under 10 years. Something is rotten in Denmark, isn't
They
it?
have no verification of a loan that's under 10 years that was used to convict the man and put him in prison. That's the most concerning part.
Yes.
It's like we have everyone can verify I believe a line of credit or whatever you want to call it, $250,000, significantly less, and 2 years older, which didn't affect anybody's life.
Right.
But the one thing that supposedly was the DNA, that's the only thing nobody has any verification of. Not simply the U.S. Attorney's Office, who I think, again, wasn't there where he's saying, hey, we shredded it, then I think that was his best guess. When he was putting together a presentation or paperwork for you guys, said, we don't have those things, and someone's like, those are probably some of the things that were shredded. That's probably some excess documents and paper that was shredded. But then how do you explain the OCC also not having any verification of a loan when banks are required to record it with the OCC?
Right.
Required by law. So either someone broke the law, not Orlando Carter, or it didn't exist.
He also has an admission by Clinton Taylor, an executive at PNC Bank for client relations, who says in a letter in 2014, 2015, that there is no documentation of a $4 million loan. They can't find documentation of a $4 million loan.
May 20th, 2015. Dear Orlando Carter, please allow me to respond to your recent inquiry received by PNC Bank. After further review, based on the information you provided, we at PNC were not able to obtain information regarding a loan in the year date of 2004 with a $4 million loan guarantee. Thank you for allowing me to clarify this matter with you. Sincerely, Clinton Taylor, PNC Bank, Executive Client Relations, Enterprise Escalation Group.
He also has from two separate records custodians at PNC Bank who, under penalty of perjury, produce authenticated and certified records of any loans.
January 10th, 2018. Orlando Carter. PNC Bank has, in response to your request for customer records, engaged in a search of bank records which by description or location would likely contain records responsive to your request. Enclosed are all the documents requested. I, Cheryl Basco, hereby certify that to the best of my knowledge, information, and belief, I declare under penalty of perjury that the foregoing is true and correct. Date, January 10th, 2018. By Cheryl Basco, Records Custodian.
They were able to produce records of the $250,000 loan that CBST had when Carter acquired the company.
An older loan that was not involved in any federal investigation.
Right.
But a younger loan that was the subject of an FBI investigation, which the U.S. Attorney's Office and the FBI has stood up and said, well, we got verification.
Right.
We got verification that we no longer have and nobody else can find.
Right.
But somehow that they got that, and that's what doesn't make any sense.
Right.
And again, to me, that's when I keep going back to the evidence, circumstantial, that maybe supports the lack of its existence.
Right.
And there is no evidence today, and they can make their statements that it used to exist, we just got rid of it. But today, there's none that exists to support its existence, only to negate it.
Right.
And when you have a case like this, which is, you just pile up the circumstantial evidence and say, well, there's overwhelming circumstantial evidence that this loan never existed.
Right.
Or somebody went way, way out of their way to erase its history.
Right. Right.
Either one needs to be opened up, investigated, and looked at.
But the significance of the DOJ ignoring the credibility of an OCC letter to the tune of there being no record of a $4 million loan speaks volumes, and I want to see if you'd be willing to address it.
Well, I think your point is such that one, Mr. Glassman, as the current U.S. Attorney for Southern Districts, has the job of a spokesperson and speaking for the OCC, which, going back to getting a letter of opinion counsel from the county prosecutor, that is their legal representation, number one. And number two, I believe where you're going with this, with the historic case law references, is that there is one government. There isn't, well, this agency does something and they're rogue and on their own. That wouldn't make any sense. And the U.S. Attorney is over here and they have a wall. And no, there is one government. And what one government finds and concludes is a decision that binds the government as a single entity. And the same could be said if you could step back in time and say, well, it stands to reason the OCC didn't have any proof of its existence. It wasn't recorded with them as required by law back in 2004, 5, 6, 7, 8, 9. And therefore, the law states that the U.S. Attorney's Office knew that because the government knew it. Why isn't anyone addressing that?
Right.
Why are they skirting that issue? And that's where I think the responses have been disappointed from the government. Not disappointing because they don't agree with everything I say or you say or anyone else, but have skirted the issues.
Right.
They downplayed or dismissed their own findings because there is one government, and that's a branch
Right.
of their sister agency finding something, and it doesn't have any merit.
So in Giglio, the Supreme Court says the DOJ is the spokesperson for one United States government, and since the Office of the Comptroller of the Currency regulates national banks and PNC, and therefore National City Bank, admits there is no loan, and the Office of the Comptroller of the Currency has no documentation of a loan, then the OCC is the expert. Is it not? I mean, they're basically saying to the DOJ, there is no loan. So for the DOJ, through the acting or the existing United States Attorney, Benjamin Glassman, to disparage or ignore or dismiss, whatever word you want to use, the OCC letter and allow an innocent man to remain in prison is, my words, gross. It's unconscionable. The truth, the whole truth, and nothing but the truth is something a lawyer seeks. Let's just apply it to a prosecutor. The prosecutor should be seeking the truth from the FBI agent Gormley, who should have gone to the OCC, and Richard Chema, the Assistant United States Attorney, should have gone to the OCC to seek the truth to confirm the existence of a loan through the expert, the agency that regulates national banks. Fair conclusion, right?
And I think we may be at a point of closure, because I think we've come full circle.
Full circle.
And Orlando's concern going and walking into with his life being on trial to jurors, the question was, did you verify? Did you seek verification? Did you get verification?
Exactly.
We did. I think that we did was truly a response saying, we asked. And right or wrongfully believed in the honesty, truthfulness of those representing the government. Mm-hmm. I believe told his counsel, yes, we have verification of it. Yes, we did these things that we're now talking about and we know were never done.
Right.
And that was the verification, or therefore the proof that it didn't exist. And coming full circle.
Right.
Is, well, the truth, if it was sought, would have been sought there. That's the verification.
Right.
But they had already gone so far beyond that document,
right,
that they have to do what I said before. They have to do a U-turn and go back.
Right.
And no one wanted to go back.
I think it's important to also note that currently United States Attorney Benjamin Glassman, and I have met and personally spoken with Mr. Glassman, refuses to acknowledge the authenticity and the veracity of the finding by the Office of the Comptroller of the Currency, an agency of the Department of the Treasury, the OCC, which is an agency that regulates national banks. He refuses to acknowledge their finding that neither you nor your company ever had a loan or a loan guarantee with National City Bank, which is now PNC Bank. So I want to ask you for your observations. You know that Assistant United States Attorney Chema did not check with the OCC. The FBI agent, Kevin Gormley, did not check with the OCC. And Glassman today refuses to accept the finding of the OCC, even though PNC has admitted that there was no loan or guarantee. What are your thoughts, sir?
Simply, they didn't do their job. Had they done their job, if they'd taken the oath that they were to do and act with integrity and honesty, they would have drew the same conclusion that the Office of the Comptroller has now drawn, that there never was a $4 million debt. There was never a $4 million loan. But for some reason, they chose to go down a different path and create a false narrative. And I have spent every day of the last almost 10 years fighting this false narrative that they have put in the public domain. It's really unfortunate that our government officials would behave the way that these individuals have behaved.
You've got an innocent guy in prison. He's in his 10th year. He's got 5 more to go. He has been deemed a vexatious litigator by the courts and by perhaps the Department of Justice, because he has filed, let's say, 5, 6, 7, 8 suits and any number of claims to gain his freedom. And I look at that and I think to myself, if an innocent man in prison doesn't fire one shot in order to gain his innocence, it says a lot about his lack of character. If a man will fight 5, 6, 10, 15 times to get home to his wife and children because he knows he's innocent and he's about the truth, then being a vexatious litigator might actually mean something. It's a cry in the wilderness saying, I'm innocent, and this letter proves it.
Will always be shut him down.
Yeah.
Not procedurally, not by labeling him, but shut him down with proof of the loan, proof of the debt, proof of his financial obligation that he should have reported, and it'll go away.
So let me ask you.
Got my word, it'll go away. That's
exactly right.
I'm sure I am.
So Nick,
give me some from the OCC, when it was recorded, and then show me what you shredded.
Why would U.S. Attorney Benjamin Glassman or the people before him not do that? Why would they not establish the authenticity of the loan and release an innocent man? What's the motivation?
I don't have the answer. I really don't. I truly believe that it can go anywhere from arrogance to laziness to racism to politics,
Scalp
to
convictions,
a combination of all those things, which I
glory,
ego,
promotion,
ego. So, well, we already know what happened.
Yeah,
I really believe that the culture, in some jurisdictions anyway, not all, where it's disprove us.
Yeah. Right.
Well, and that's again goes back to a culture with him prosecuting attorneys, I guess, on many levels. I'm not pointing out anybody in particular that truly believe their job is to get a conviction
at all costs.
Yeah, and that's why Brady and these other line of cases and discovery rules had to be put in place.
Mm-hmm.
Why in the world would you have to put a rule in a law in place that says we're requiring you to tell the truth? We're requiring you to give evidence that shows innocence.
Right. Yeah. Meanwhile, the ABA is asking you to do that too.
Yeah.
You're bound by ethics.
Why are those even thoughts in someone's head to have to put in the paper, put in the statute, put in a rule,
right?
Put in the model code of professional behavior? Why?
Right.
Because we have to tell a certain segment to say, you have to tell the truth, Johnny. And also, if you possess something that no one else has, and it shows that that person didn't do the crime you're prosecuting for, you have to show it to them.
Yeah.
You think the inclination would be, I'm going to run over there, bang on the door, and be like, I got this.
Right.
But no, they have to be told.
Yeah.
That's why there has to be these checks and balances.
Right.
They're supposed to be.
Now that we have a comprehensive understanding of what happened in the government's case against Orlando Carter, let's step back and look at the four corners of justice diagram from the macro perspective. Let me first direct your attention to the diagram and note once again the zero line that runs through the center of the diamond. If everything is objective, the scores will be 0. If something is detrimental to the alleged criminal, it will be negative on the left side. If there's a positive, it'll be registered on the right side. As the most incarcerated country in the world, we have to conclude that we should expect scores to be on the negative side. There's a reason that innocent people go to prison. There's a reason Orlando Carter is in prison. Let's take a look at Carter's case, and let's focus briefly on the left side of the diagram and look at the components of the system. The people are the most powerful, at least ostensibly, right? We may not exercise the power, but the electorate and the grand jury and the jury are powerful components of the judicial system. Now, we're going to focus on the investigators because we know what happened with FBI agent Kevin Gormley. He is a focused power, and so if we look at his lack of training and we look at his failure to investigate National City Bank or question their motives and why they actually submitted a suspicious activity report, and if we then weigh his refusal to accept or to investigate testimony of witnesses that would disprove the existence of the loan. And then finally, if we weigh his failure to coordinate with the OCC to determine the existence of a loan, we should rate FBI agent Kevin Gormley as a -5. We can then move to the prosecution. Assistant United States Attorney Richard Chema failed to coordinate with the OCC. He failed to question and investigate adequately the motivations and the practices of a bank that was already in trouble with the federal government. We should rate Richard Chema appropriately for introducing, for example, fake evidence into court, attesting to the existence of a loan and a guarantee when in fact he failed to confirm that very evidence. I'm going to rate Richard Chema as a -7. It's my opinion that both FBI agent Kevin Gormley and the prosecution, Richard Chema, they failed miserably. Not only their office, but their country, and certainly Orlando Carter. Let's jump briefly down to the witnesses. We do know that Sean McAllister was the underwriter at National City Bank, and he told FBI agent Gormley that in fact the loan guarantee was not adequate. We also know from the other witness, and we didn't go into a lot of witnesses, but we do know that Anthony Schweier, the auditor, testified for the government that in fact there was a loan. And we can recall that Dominic Mango indicated that that Schweier's testimony could have been considered perjury. So we have to rate the witnesses and do it negatively. I'm going to give them a -5. The defense lawyers, we know they failed Carter horribly. They did not investigate the loan or the guarantee. They did not defend their client. Carter was defenseless in essence. It's noteworthy that when somebody alleges ineffective assistance of defense counsel, they can submit what's called a 2255. He did that after his conviction, and the attorneys testified under penalty of perjury under oath that they failed to confirm the existence of a loan. Surprisingly, Judge Beckwith did not grant Carter a new trial. That should have been something that would have moved mountains for Carter. I'm going to rate the defense attorneys at -7. I'm going to move quickly to the judge. We do know that Judge Sandra Beckwith not only admitted the loan guarantee, which impressed upon the jurors that in fact there probably was a loan, the judge holding a lot of sway and power in the court. That simple act ill-served Carter. At the same time, she denied the admission of the National City email with National City Bank among the executives and its general counsel being concerned about their own improprieties with their own transactions with Butler County. I'm going to rate Judge Sandra Beckwith as a -9. We can look at the score and see we've got 21, 28, 32. I'm going to put this as a -32 on the negative side. We can see that there is no positive benefit from this in Carter's behalf as far as seeking his exoneration and his innocence. Now, why is this important? If we're the most incarcerated country in the world, whether it's at the local, state, or federal level, there are literally hundreds of thousands of investigators and agents, prosecutors, assistant prosecutors, and judges or magistrate judges who run afoul of general procedure, protocol, the law, or doing what is right and true and just. This diagram will hopefully allow us as lay people to take a snapshot of a case and realize simply because an agent or a prosecutor or a judge says it does not make it so. It doesn't mean it's just or truthful. And we should hold them with suspicion. This is important because I'm going to bring a document my way. This is significant because the current U.S. Attorney in Cincinnati, Benjamin Glassman, to this very day refuses to acknowledge the significance of the finding by the Office of the Comptroller of the Currency. In fact, in a recent court document, he stated to the court that the facts established at Carter's jury trial, and then he goes on to talk about a letter of counsel guarantee. Notice the word change there. Again, words are never consistent in the government's case against Carter. It's not a loan guarantee. It's now a letter of counsel guarantee. I don't know what that is. I don't know that Glassman knows what that is. And then he talks about arising out of a loan to a local government. Now, it wasn't a loan to a local government. It was a lease, and it was a purchase by National City with product going to Carter and his company on behalf of Butler County. Carter and his company served as a vendor to National City and to Butler County. But it is noteworthy that we have a U.S. attorney in Benjamin Glassman who talks about a loan to a local government. There never was a loan, Mr. Glassman, and it was a lease. And National City had problems with the lease, and Carter has been saying for more than 10 years that there wasn't a loan, that he had no liability, that there was no loan guarantee. This is a current document that the government has submitted into court that refutes what National City represents and what it has been saying and what PNC currently says, because PNC Bank currently agrees with the Office of the Comptroller of the Currency that there was no loan. There could be no loan guarantee. So I hope this diagram is helpful. I hope that you use it, and I hope that you can impress upon yourself and other people that, in fact, people like Carter need help. We should not be the most incarcerated country in the world. There are solutions, and it begins with our direct engagement. Our limited discussion of the federal government's prosecution and conviction of Orlando Carter should have demonstrated adequately how the components within the judicial system actually ensure injustice. The four corners of justice diagram quantifies and qualifies how rogue agents and agencies defy the law, as well as ethical and moral accountability. In Carter's case, we are certain the FBI and DOJ exerted authority without the requisite jurisdiction. The government's case against Orlando Carter is even more tragic simply because of the actions and decisions of the current United States Attorney, Benjamin Glassman. At this very moment, Glassman knows the OCC and PNC Bank, which acquired National City, have stated there is and was no $4 million debt, loan, or obligation, which is what Ted Johnson certified in sworn affidavits years ago. Glassman knows the FBI and DOJ never investigated Jim Smith and National City Bank in its questionable suspicious activity report. Rather, the FBI and DOJ used Smith and National City to secure hollow and corrupt convictions. The Carter case has red flags all over the legal landscape, which Glassman refuses to acknowledge. Judge Beckwith called the $4 million loan the centerpiece of the government's case. Glassman must recognize the truth. If there is no loan, according to the Department of the Treasury, there can be no centerpiece to the government's case. There can be no crime of bank fraud. The harsh reality is that Carter is serving his 10th year of a 15-year sentence, and Kay Rogers is paying restitution of $4 million for a loan that does not and never existed. PNC Bank is receiving monthly payments from Kay Rogers. These payments are pure profit. Why? PNC Bank does not have a loss against which Rogers' payments are credited. If Glassman does not find these conclusions at all inconsistent with the law or his responsibilities, it would not be unreasonable to classify him as volitionally blind. He does not seek truth or justice. Glassman is affected by unhealthy arrogance, even if manifested by the system itself. We should not be surprised that the Baptist Ministers Conference in Cincinnati, Ohio, has called for Glassman to resign. The BMC views Carter's imprisonment no differently than the shooting of an innocent black man by police. Is this an unfair comparison? Imagine spending years behind prison bars. Imagine a wife and children losing a husband and a father for 15 years because of the federal government's mistakes. Carter's case only lacks the blood and sensationalism needed to encourage a healthy contempt by the entire Cincinnati community. Now consider that the prestige of the United States government gives the Carter case credibility. Who is going to question the integrity of either Glassman or the federal government? Orlando Carter? Given this stacked deck, there is no reason for Glassman to demonstrate the moral character expected of a United States attorney. Glassman is able to defy truth as well as justice. Dominic Mango made a telling observation. After discussing Carter's repeated efforts to overcome the government's unjust conviction and his imprisonment, Mr. Mango recommended that Glassman shut Carter down. Shut his efforts down by proving that the loan exists. Why doesn't Glassman prove there was and is a $4 million debt and defeat any attempt by Carter to prevail in court? If Glassman were to prove the authenticity of the debt, he would not need to exploit court rules and procedures to preserve this sham conviction and deny justice. Glassman will not treat Carter in the same manner he would treat his next-door neighbor in a very simple dispute. No. Glassman uses rules and procedures in order to avoid the core elements of the government's deceit. Glassman will not say, for example, Mr. Carter, here is the loan you had with National City. Now serve the rest of your prison sentence without complaint. You see, if Glassman were to do so, Carter would stop fighting. Within our current system, Glassman does not have to do what is right, what is true, and just. Glassman hides behind and uses the system itself. With his neighbor, he is at least expected to act honorably, unless Glassman is actually a dishonorable man. To be sure, the judicial system allows dishonorable conduct by government officials. That Americans are woefully ignorant of the extent of the justice system's failures cannot be refuted. Americans are ignorant, apathetic, and fearful. The justice system and its officials are arrogant. If we permit the system to remain, if we permit the likes of Glassman and Beckwith to remain in office, we should expect, as Americans, to be the most incarcerated people in the world. What is the solution? There are many. Paramount, though, we should become enlightened, involved, and fearless. What should we do about Carter's case? We should contact Benjamin Glassman. Call him at the U.S. Attorney's Office in downtown Cincinnati, Ohio, and hold him accountable for the lie that he fosters. Ask Glassman to prove the existence of a $4 million loan or seek Carter's exoneration. If Glassman fails, we should demand his resignation. We should contact President Trump and ask him to open a criminal probe into the FBI and DOJ handling of the Carter case. We should call Judge Susan DeLotte and ask the federal court in Cincinnati, Ohio to correct this wrong. We should share this video with friends and sign the petition asking for Glassman to resign. We should share this petition with the good and deserving people of Cincinnati and all Americans. Unless and until we right the wrongs committed against innocent Americans, we should not expect to be a free people. Candidly, we are a conquered people. The end of justice results from the absence of truth. Let us resolve for truth in the high hope that justice and freedom will once again triumph in the land of the free and the home of the brave. Orlando Carter deserves our resolve. Our posterity deserves no less. We deserve a virtuous justice system.